Hello, everyone. At the webinar of DPO Europe GmbH devoted to the regulation of data privacy in United Arab Emirates. So let me start with the introduction of our speakers, of ourselves. My name is Siarhei Varankevich. I'm a founder of Data Privacy Group, Data Privacy Office, and Data Privacy School companies. I'm a manager, technologist, and professional in the area of information privacy and certified professional in those areas. I'm IAPP Fellow of Information Privacy, and he's been delivering the training course on the GDPR since 2013. And also I plan to deliver the training on UAE regulation pretty soon. My colleague here, Denis Sadovnikov, he'll introduce himself.
Hi friends, hi colleagues. I'm Denis Sadovnikov. I'm Practice Data Protection Officer, and I'm working at the forefront of cutting-edge technologies at the AI and ML department of the largest bank in Russia. And previously, I worked as an in-house lawyer, as head of legal and head of GR department. I'm also certified as a data privacy professional for Europe and as a data privacy professional under GDPR and GDPR DPM. And also I have two Russian academic degrees in law and in history. And currently I am obtaining my British degree in law at the University of London. And now, Sergey, I think we can provide some general introduction of our webinar, just to bring our audience in the course of our discussion.
Yeah, I agree. So go on.
As you all know, a couple of recent years, mainly 2021 and 2020, a lot of jurisdictions worldwide, across the world, passed the data protection legislation. The enormous influence of the GDPR may be illustrated in these new pieces of legislation in different jurisdictions. The United Arab Emirates is one of the prominent examples of such new legislation. And as you can see, in 2020, the first emirate, Dubai, passed its data protection legislation, and then Abu Dhabi, another emirate, also enacted its legislation. And just at the beginning of this year, in January this year, the federal law of the United Arab Emirates has come into force, and other countries of the Middle East, other Arabic countries follow the example of the United Arab Emirates and also enact their legislation. These processes are closely connected to the enormous efforts of Arabic countries to become leaders, world leaders in the field of new economy, which is according to some predictions should be AI driven. And this new legislation is a part of the efforts to become the global business and data hub and to become the world AI destination. And that's why it's important. And other thing, that's why it's important to know data protection legislation and to be in the course of it in the United Arab Emirates, is that the current tensions in the world, current political and economical tensions, change the roads of business, change the roads of goods, of services, and of data. And the United Arab Emirates, which enacted modern legislation of data protection, provides some opportunities for global business to create, to build new business roads and new floods of data transfer. That's why it's impossible to consider during the one webinar the whole data protection legislation of the whole country in details. But we should concentrate on some important or maybe introductory points. First of all, we going to consider the data protection legislation of the United Arab Emirates in the context, in the legal context, in the context of the legal system, because it's obvious that even the same piece of legislation, which is brought to different legal environment, to different legal culture, legal tradition, will work differently. And as Ivor Jennings said, the legal rules is the dry bone. And the flesh which clothes this dry bone is other elements such as traditions, such as cultures, such as legal environment. And then we want to discuss material and territorial scope of the three different legal frameworks which exist in the United Arab Emirates. And then we intend to pay some attention to data protection officer, its statutes, its appointment requirements, and differences between United Arab Emirates framework and GDPR at this point.
Let's start with these three levels of regulation. And on this chart, you see those three levels. First of all, federal level of United Arab Emirates and the level of the Emirates themselves. And some Emirates like Abu Dhabi and Dubai have created free zones. So data protection legislation is represented on the first and third levels of this system. So data protection laws exist right now on the level of federation and on the level of those free zones. In this webinar, we'll be focusing on two of those free zones, on Abu Dhabi Global Market and Dubai International Financial Center. But before we go into this data protection, first let's have a glance at the legal basis for those privacy laws, and we will start with the Constitution.
As we already mentioned previously, each piece of legislation works environment, and the base of the legal environment for each legal system is, of course, a constitution. As all countries in the world, the United Arab Emirates also has its constitution, and it was enacted, it was passed by heads of 7 Emirates, which are composed the Federation of the United Arab Emirates. And what's important for us that this constitution passed in 1970s provides some basic human rights which are important for the data protection. First of all, it provides people with freedom of opinion, freedom of expression, and freedom of information. It's an important right which usually is considered as corresponding to the right to privacy. For instance, an example of the European Convention of Human Rights, it's Article 10, which corresponds to Article 8. And the same situation is United Arab Emirates. And then we have Article 31st, which guarantees communication secrecy. According to Islamic legal tradition, this right, as the next one, sanctity of home, stems from the Islamic law, stems from the Holy Quran, and these rights are guaranteed in the United Arab Emirates. Not only according to the constitution itself, but also according to the Sharia law, which also, according to the Article 7 of the constitution, is the primary source of law in the United Arab Emirates. And it's not necessary to discuss this point in details. We can move on to the court system. The court system of United Arab Emirates is complicated. First of all, it's divided into two levels, the federal level and Emirates level. Each level is competent to consider the cases according to its competence established in law. And it's important to mention that additionally to this division into two levels, there is another division into branches. First of all, we have civil courts, which some common cases. And also we have Sharia courts, which apply Sharia law and which is applicable mainly in relationships between Muslims and citizens of the United Arab Emirates. Mostly Sharia and Sharia courts is not connected, is indifferent to foreign business and to data protection.
More applicable to family law.
Yes, of course. Mostly applicable to family law. Yes, exactly. Thanks. And then we can move on. It's also not necessary to consider this topic in details. we can move to the system of governance of the country.
UAE as a federal state has two levels of ruling. First of all, on the federal level, we have a system that consists of the Federal Supreme Council, which is composed of 7 sheikhs that elect President of UAE and Prime Minister of UAE. The decisions that Federal Supreme Council takes are reviewed by President and Prime Minister. And there is also executive branch, the Council of Ministers, and Federal National Council with advisory powers. On the emirate level, each emirate is a hereditary monarchy, and most of the decisions and laws are coming from the sheikh side. When we speak about sources of law, Denis will explain these 4 major sources.
We already mentioned the constitution, and already we mentioned Islamic Sharia, which also the primary source of law. Also, we have as a source of law statutory law, which is represented by statutes which passed by rulers or by some other organs. It depends on the context, and it depends of the context of federal level or of the particular emirate. Also, international treaties are recognized as the source of law in the United Arab Emirates, and it also should be taken into account in particular legal issues. And also it should be mentioned that decisions of the Supreme Court are persuasive, not binding. In contrast to common law legal system, some decisions of this highest courts are binding according to the doctrine of the judicial precedent. We don't have the doctrine of the precedent in the United Arab Emirates, at least on the federal level, but we have some elements of common law system, of common law legal tradition on the level of Emirates, mostly on the level of Abu Dhabi, which directly reference to the common law legal system and to the English law, which is directly applicable in some contexts in the free zone of Abu Dhabi.
So as I told before, we have data protection laws on 2 levels, on the federal level and on the level of the free zones. And one of the major free zones is Dubai International Financial Center. And we have 2 pieces of legislation that govern information privacy. First of all, the data protection law of 2020 that was adopted by ruler. It is in force since July 2020. And also we have regulations adopted by the FCA Board of Directors. This regulation explains some of the major provisions of the data protection law. We have the similar system in Abu Dhabi, and Denis will explain this one.
Yes, but we have some differences between the legislation of Abu Dhabi and legislation of Dubai. First of all, on the level of the Abu Dhabi global market, we have only 1 piece of legislation, not 2, in contrast to Dubai. This is headed as regulations, but actually it's likely the primary law, not secondary. We should mention here that the legislation procedure is different in Abu Dhabi global market. It has some differences from Dubai International Financial Center, and these regulations are adopted by Abu Dhabi Global Market Board of Directors, but actually it's on the same legal statutes as the primary law of Dubai. Also, it should be mentioned here that in contrast to Dubai, Abu Dhabi Global Market in its legislation is follow the common law approach, and there are a lot of direct references to English common law, to English precedents, and to the guidelines of ICO, Commissioner's Office. It's the United Kingdom Supervising Authorities. And these points should be bear in mind always when we deal with the legislation of the Abu Dhabi. We have some questions.
Yeah, it's about documents. Those documents that we mentioned, both laws and regulations, especially in free zones, are available online. So you could access the websites of those free zones and download them, which is a little bit different from federal level. And this is a good time to explain this interplay between the federal law, federal regulation, and the regulations laws of free zones. First of all, I need to say that although federal law, which was adopted in 2021 and enacted in 22 is applicable around the whole federation, but there are exemptions, and those areas that are governed by special laws, they're regulated by them. So you see on this diagram that the federal decree law number 45 is applicable in the whole UAE, but in case of companies that are active in free zones, we have some exceptions. Let's better start with the federal regulation. And the territorial scope of the federal law is quite straightforward. So it's very similar what we have in the GDPR. First of all, if you are a controller or processor inside UAE, you have to follow the federal law. But even if you are not established as a company in United Arab Emirates, there might be cases when you process the personal data of data subjects that are inside of United Arab Emirates. And if this is the case, then you have to follow UAE law too. But if you are outside UAE and you also don't process the personal data from within UAE, the United Arab Emirates law does not apply. But of course, there are exceptions, would be Dubai International Financial Center. So as more specific law, it would be prevailing. It has its own articles devoted to the territorial scope, Article 6 of the law. And Denis, I'm turning the floor to you.
First of all, I would like to add to Sergei's answers of questions about accessibility of legislation of the United Arab Emirates. First of all, I would like to say that the legislation of free economic zones publicly available in English, and English variant is official, in contrast to federal level. On the federal level, we have English documents only as an official translation, but each free economical zone has its official website where we have legislation and guidelines in details in English. And English is a official variant, we can use it, and also English is a working language, business language in many cases in free economical zones. So what about the territorial scope of the Dubai International Financial Center data protection law? We have two criteria of territorial applicability of this law. The first one is the criteria of incorporation. Controller or processor should be incorporated in the Dubai International Financial Center. Incorporation, the criteria of incorporation according to the guidelines which provides by the Data Protection Authority of the free zone. This term, incorporation, is considered widely. It may be not only official registration of the entity, but it may be some branch, some element of entity which is incorporated in Dubai. The first criteria is a processing activity should be physically take place within the Dubai International Financial Center. It means that according to the legal explanation, it means that means, equipment, or personnel which are involved in the process of data processing should be located physically within the territory of the free zone. Both criteria are quite straightforward, and there is no any tricky elements. It's quite easy to apply. And in contrast to GDPR, here we can see that the old criteria pre-GDPR is used, location of equipment and personnel, which was used in the European Community Directive of 1998, which was previously GDPR.
And when speaking about Abu Dhabi, the global market data protection regulation, we have a much more complicated way of defining the scope of the regulation. You can see here the three scenarios. The first scenario when ADGM regulations apply fully, another scenario where they apply partially, and scenarios when ADGM regulations do not apply. Let's read this diagram starting from the up. The first question would be whether the processing is in the context of activities of an establishment of controller or processor in the global market. You can see the wording very similar to Article 3, Paragraph 1 of the GDPR. When using this wording, establishment doesn't necessarily mean a legal entity. It could be any persistent activity in global market. And the context of activities could be also explained in the similar way as it was explained in Google Spain case. But since we don't have this broad number of court cases and decisions, it still leaves a lot of area for interpretation. And I think the legislation and practice might go another way in Abu Dhabi. If the processing is not in the context of the activity, then ADGM regulations does not apply. It's quite straightforward, but there is an exception for processors. And if you are a processor, in certain cases, the ADGM regulations will be partially applicable to you. What are those cases? First of all, you should be a processor. Then your controller, the controller that determines the means and purposes of the processing, is outside global market. When you answered the question about the controller is outside ADGM, yes, then another question arises whether the controller's domestic law has similar obligations. And if it has similar obligations in case of contradiction between ADGM regulations and this domestic law of the controller, then the domestic law of the controller applies. ADGM regulations give way to applicability of the some domestic law of the controller. And but if you are not a processor, or you are a processor of some company whose domestic law does not contradict ADGM regulations, then regulations apply in full extent. We covered the territorial scope of both Federation, International Financial Center of Dubai, and Abu Dhabi Global Market Data Protection Regulations. We must also tell a couple of words on material scope and exemptions that exist in the articles devoted to material scope. And we will start with the federal level.
But we have a question about Dubai International Financial Center and territorial applicability of its law. The question is, a controller is incorporated in other country, but the processor is in DIFC, then the DIFC law applies regardless of the applicability of the controller's domicile law. Yes, exactly. There is potential conflict of applicability of law, potential interlocated collision, and as well as other legal frameworks in the world, Dubai International Financial Center provides here that its law is applicable for this situation, for this case. Also, I would like to add that such processing not be occasional, should be the part of a stable arrangement. It's directly provides in law that it should be the part of a stable arrangement. Let's move on to material scope of the federal law, number 45. There is also one main criteria, and it's quite straightforward. The law is applicable to processing which takes place by automated means. There is no guidelines about automated means and no explanation, official explanation provided, but I think that we should consider the term of automated means in its usual meaning, its common meaning. Usually it means that some software, some computer technology are involved in this process, and usually it means that the processing takes place by automated means. But the federal legislation has a lot of exceptions from this rule. These exceptions are prominent, and the amount of these exceptions are much wider than the similar exceptions in GDPR. First of all, we have exceptions of government data. All government data are excluded from the scope of the federal law of data protection. Also, there is a special exception data of government's authorities who act as a controller or processor of personal data. Also, judicial authorities specially accepted from the scope of law. Also, health personal data also accepted, but what about health personal data? There is a special legislation, several special pieces of legislation which regulate the processing of health data on the federal level of the United Arab Emirates. Also, there is a direct, explicit exception of companies and institutions which are within the scope of data protection legislation of free zones, as Sergei already mentioned. Also, financial area, financial sphere also is accepted from the scope of this law. It's a similar case of the case of health data. We have also the special regulation in this field. Also, we have traditional household exemption. We further can see the same situation in all three pieces of legislation, that household data, household activity direct exempted from the scope of law. It's the same situation as in GDPR and, for example, in Russian law and so on. Also, we have another interesting point. We have the special right of the Office of Data Protection to provide additional criteria of applicability of data protection law on the federal level. This right is directly, explicitly provided by the law. The Office of Data Protection may exempt some establishments, some entities from the scope of this law. It's an interesting example, and I know only one similar example in the world. It's China.
And in DIFC law, we have similar provision to the one that is in the GDPR in Article 2, except along with automated means as a first criteria for deciding whether this law is applicable to the processing, we have also additional criteria that are connected with filing systems. But let's look at this diagram. So if your processing is conducted by automated means, by a computer, server, software, then you go to the question about the personal or household activities exception. And if your activity is conducted within your usual activities of the business, then you are within the material scope of the DFC law. It's quite straightforward. But what about filing systems? So in case your database is in a paper catalog, which is a filing system, then additional question should be asked whether this paper catalog, this additional question of the exception is applied, and then you automatically get into the material scope if you answer that this exception is not applicable. But also there are some cases when you collect information in paper form and it doesn't look like a catalog, like some kind of database, but it is intended to form a part of filing system. For instance, it's going to be added into some cards of your employees or patients. Then, since this information on the piece of paper is intended to be a part of this filing system, then you also go to the question about the exception and go into the materials of the law. If you answer all those questions negatively about automated means and filing system, your activity is outside of the material scope. And one last chance to get rid of the burdensome provisions of the law is to use this personal or household activity exception. In all other cases, you have to comply and follow DFC law, provided that the territorial scope of the law that Denis showed earlier is working for you. About ADGM, Data Protection Regulations material scope, Denis will tell something very similar.
We can see that ADGM adopted a very similar approach, but there is some differences. First of all, we have criteria of automated means. This is the same as on the federal level and in other emirate. Then we say criteria of filing system, or if data is intended to become part of filing system. Also the same situation as in Dubai. And also I would like to add here that we have useful guidelines from ADGM Data Protection Authority, which provides clear explanations of the point of filing system, of the point of automated means, and of the point of intended to become or to form part of filing system. Yeah. In contrast to Dubai, these explanations, these guidelines in Abu Dhabi is much more detailed and generally follow the approach of the British ICO, Information Commissioner's Office. Also, we have some exceptions in Abu Dhabi. It's traditional household exception, but also we have so-called enforcement exception, which is provided similar manner as GDPR. GDPR also includes this kind of exception. Usually it means that there is some special piece of legislation which regulates data processing by law enforcement authorities. The same situation is in Abu Dhabi. Let's move on to Data Protection Officer.
Data Protection Officer is a part of all three of the legislations, and we will start with the federal level. There are three cases when appointment of DPO is necessary, is required. This is the large amount of sensitive data processed by the company, and the executive regulations may specify criteria for determining this large, what constitutes large amount of sensitive data. There also could be a situation of new technologies that are designed to process data in the way that it may pose a high-level risk to confidentiality and privacy of data subjects. A systematic and comprehensive assessment of sensitive personal data, including profiling and automated processing. Those three criteria are the only criteria on the federal level that are used to force businesses to appoint data protection officer. When speaking about appointment, we need to also mention that the appointment is connected with certain obligations. First of the obligations is the requirement to notify supervisory authority about DPO appointed by your company. You should appoint a DPO within territory of UAE, so DPO should live in UAE, should be a UAE company or a UAE person, with one exception. So you may appoint DPO outside UAE if you are part of international group and this person is outside UAE, but also plays a role of DPO of the whole group. So when speaking about Dubai International Financial Center, Denis will show also the case of voluntary appointment.
And mandatory appointment. First of all, we can see here that Dubai International Financial Center at this point adopted very similar approach to GDPR. First of all, we can see at the requirements for the mandatory appointment of DPO. They are very similar to the same in GDPR. First of all, public bodies, except courts, should appoint the data protection officer. In GDPR, we have the same situation. Also, the second requirement is high-risk processing activities on a systematic or regular basis. There is some difference from GDPR where we are speaking about the core activities. The third criteria may be provided by the Commissioner of Data Protection of Dubai, and according to the law, the Commissioner has such power, has such authority to establish additional requirements for mandatory appointment of DPO. Additionally to mandatory appointment of DPO, DPO may be appointed voluntary. But in the case if the entity, controller or processor decides to appoint DPO voluntary, it means that this DPO and his statutes and his tasks and powers should be the same as in the case of mandatory appointment of DPO. There shouldn't be any differences. It's interesting and one of the key provisions of this part of legislation. And also we have some requirements of location of DPO and about communication of controller of processor with data protection authority for DPO appointment. First of all, as in the case of federal level, as and also in the case of GDPR and other legal frameworks in the world, a DPO may be appointed for a single entity or may be appointed for the group of companies. Generally, DPO should be located within the Dubai International Financial Center. But in the case if DPO is appointed as a single person for the group of companies and not all elements of this group is allocated within DIFC, he can be located outside the DIFC. But the general rule is that he should be within Dubai International Financial Center. Also, DPO may be in-house or may be appointed according to the contract and so-called site DPO or external DPO. This practice is lawful in Dubai. The contact details of the DPO should be available publicly, and also the information about DPO appointment should be provided for the commissioner for Data Protection Authority. And on request of controller or processor, DPO should confirm his identity as a DPO, and this point is under the control of the Data Protection Authority. The interesting point here that DPO, it's explicitly provided in law that DPO may hold its role as a DPO alongside with other roles and other tasks in organization, but there shouldn't be conflict of interest and a conflict of tasks between tasks of the DPO, which he should pursue according to the law, and other tasks which he holds.
Let's move to Abu Dhabi. In Abu Dhabi case, you may see the requirements to appoint DPO that's depending on whether you are a public body or not, whether your core activities include regular and systematic monitoring of data subjects on large scale, and where your core activities include processing of special categories of personal data. Where what you don't see among the criteria for mandatory designation of the DPO is high risks. So in comparison with Dubai, where you had high-risk processing as a criteria for appointing DPO, Abu Dhabi global market law regulations does not contain this kind of criteria. And there is also an exclusion. So if your business is fewer than 5 employees and does not pose high risk to the data subjects, then the designation of the DPO is not necessary. Similarly, DPO, when appointed for ADGM entities, should be reported. You should notify the commissioner about the appointment. And there is 1 month to do this. Of course, DPO may combine different roles within your organizations, and there is also a provision that allows you to appoint someone outside of your staff. There are some provisions concerned that say that in respect of a single entity or group level, there could be a DPO that resides outside ADGM. Let's move to the requirements to the DPO.
Requirements for the DPO are quite straightforward. Generally, this similar approach is adopted by all 3 legal frameworks which we are currently considering. Generally, DPO should have sufficient skills and knowledge to perform its role, and also, according to the legislation of Dubai, he should be able to act with complete independence, to act independently, and to perform its tasks properly. The requirements here in all 3 cases are quite similar to the same provided by the GDPR. And also, I would like to mention that according to the guidelines provided by the data protection authorities, in Dubai and in Abu Dhabi, there is some detailization of knowledge and skills of the DPO, but this detailization is not in much details. Generally, there is likely a practice approach to establish whether the particular person is fulfill the criteria or not. And also, it should be mentioned that currently the official certification of the DPO for this role in United Arab Emirates doesn't exist. And there is the general certification of IAPP, of CIPPA, Asia, but we can see that data protection legislation in the United Arab Emirates has much more similarities with English and European legislation of such regions as Far East, such countries as China. Generally, it should be mentioned that the person who is trained, who is educated for the role of DPO for Europe may be a suitable candidate for the DPO in the United Arab Emirates.
Yeah, certainly. When building the training program for a DPO, it's of course it should focus on UAE regulations and laws, but since the basis is taken from other regions, especially European Union and Great Britain, certain guidelines and certain approaches would be very useful, and not only in legal field, but also in managerial field, because such requirements as DPIA or having a ROPA, register of processing activities, also exist in UAE. This is one of the reasons why we adopted such approach when developing the UAE Data Protection Officer course, that we include both approaches into the course. First of all, we give the basis for understanding the personal data, the processing, the international data transfers, etc. And then we built on this basis certain knowledge that is UAE specific. When speaking about the obligations of the controller and processor towards DPO, we must see that we have certain guarantees for DPO to fulfill his her role successfully. First of all, necessary resources and support to perform the duties. We also should provide DPO the access to the decisions, to access to the processes that involve personal data. So all the matters should be known to a DPO, no secrets from your DPO, regardless whether it's in-house or out staff. There is also a guarantee of certain independence. For instance, we cannot fire DPO or terminate his contracts based on the performance of his or her duties. And we also have the provision that says there should be no conflict of interest. So combining such roles as head of marketing with DPO role is not possible, since there is an embedded conflict of interest in such combination of the duties. We saw the provisions that I referred to were from federal decree law, and now let's look what is on Dubai level.
It's an interesting approach adopted in Dubai. This approach seems to be interesting from the point of legal technique, because we have two articles, and each article includes some obligations for the side of processor controller or for the side of DPO itself. And these requirements, these obligations corresponding each other. If we consider these obligations, these requirements in the whole and look around, we can see that the result of the statutes of DPO is mostly the same as GDPR requires. First of all, we have the requirement of independency of the DPO, and we can see it in the requirement that the DPO must act independently, and also the corresponding obligation of the controller processor, who should provide this opportunity to act independently. The same situation is for resources. Resources which should be provided for DPO. Also, we have a requirement that he gets sufficient resources, and we have the obligation on the side of controller processor who should provide such opportunity, who should provide the DPO with sufficient resources. And also we have the requirement of access and report of the DPO to the senior management, senior level of management of organization. It's important requirement. Also we have it in GDPR, and now we have it in Dubai. It one of the most important guarantees of independence of the DPO, and it's important element of its statutes in organization. Also, DPO should be involved in a timely manner in all processes which are connected to the data protection issues. It's also important, and it sounds clear, but it's not always clear and easy to implement in practice. And also some guidelines from the supervising authority, from the data protection authority helps us, but maybe the professional advice in this area also is needed.
Yeah, and when speaking about Abu Dhabi global market DPO roles, we see similar guarantees to DPO. For instance, inclusion into all important decisions regarding personal data, resources and access, and immunity, along with the very important point of being high enough in hierarchy to report directly to the highest level of the management. Now, let's move to the responsibilities of this role, what data protection officer is obliged to do, and we'll start with the federal level.
On the federal level, the legislator adopted similarly the same approach as the European legislator, and the main area of responsibility of the DPO is compliance with data protection requirements. These are requirements of the particular law which we now consider. But it also requirements of other laws and other pieces of legislation and other sources of law which are connected to the data protection and to privacy protection. That's why it's important to know not only one piece of legislation for the practice activity, but also general knowledge of the whole legal system and of the whole system of regulation and data and privacy protection in the United Arab Emirates. Data protection officer, according to the federal law, is responsible for verifying the quality and validity of the procedures in organization. Also, he is responsible for data subject requests, and he should play the role of liaison between controller or processor on the one side and data subjects on another side. And the same role he plays in the field of communication with the data protection authority. And we can say that data protection officer plays the role of some kind of agent of data protection authority and defender of rights of data subject within the controller. But if in the GDPR we can this role likely impliedly, here we have explicit provisions of legislation that data protection officers should act mainly for the interests of data subject and for the powers of data protection authority. And also we have, as well as in GDPR, also confidentiality obligations on the side of data protection officers. It means the kind of professional secrecy. New kind of professional secrecy. It means that all personal data and all information connected to the personal data which become known for data protection officer in connection to pursuing of his responsibilities should be kept in secret. And also he has some kind of immunity in the field of judicial and law enforcement procedure, likely as professional secrecy of advocates or secret of confession.
So let's move on to Dubai. So we just saw on the federal level that there are a lot of obligations of the DPO, and you can see some new obligations in comparison with what Denis said. For instance, here you see explicit requirement to give advice regarding DPA, data protection impact assessment, that is a part of Dubai law. Also, we see similar provisions to what we see on the federal level about cooperation and communication with the commissioner, supervisory authority, and quite unique point here about the annual assessment that should be conducted by the DPO and reported to supervisory authority. When speaking about Abu Dhabi, Denis will proceed.
Generally, we have the same requirements in Abu Dhabi as in Dubai, but in contrast to Dubai, we don't have the special procedure of annual assessment. It's a feature of Dubai legal framework, and it should be considered in details, but we don't have such opportunity during the ongoing webinar. It's worth to be the topic of the special
training or special
training.
webinar. Yeah.
It's important provision of legislation, it's important institution of the framework. And speaking about the role of the DPO in Abu Dhabi, generally, yes, it's similar, but we should also point it out that DPO is not the controller under the processing activity. It's not the role of some external role. Yeah, it's likely he should be directly involved in the activity of data processor on controller, and he should help providing professional advice, providing relevant information, providing updated guidelines from the Data Protection Authority. He should help the controller or processor to be compliant with law and to be compliant with the rights of data subjects, which the main point, the main value defended by the legislation and by the whole system. And also confidentiality obligations also exist here, and other requirements that we already considered on the example of Dubai and federal level.
So I think it's time to sum up what we have just showed and discussed at this webinar. Denis, would you like to sum up?
We should mention that we considered some basic pillars of the data protection legislation of the United Arab Emirates. We considered these legislations as three different legal frameworks in their context, in their legal in traditional environment. And it's important to understand how can this legislation operate. And then we considered material and territorial scope of each data protection system. And also we considered in some details the issues of the DPO, of Data Protection Officer, its appointment, requirements for this role, his statutes, and his main tasks and responsibility. But it should be mentioned that each of the topics which we discussed today is worth to be the topic, to be the issue of particular training, because there are a lot of details which we couldn't explain, couldn't discuss because of time, because of limitation.
Yeah, and in addition, I would say that not only we missed certain details regarding territorial material scope and the position of the DPO, but also there are a lot of topics outside the scope of our webinar. For instance, how would you apply certain data protection principles in certain jurisdictions? How would you define the roles of data controller and data processor? What is with international data transfer, which is very important topic because of the central role of free zones in current data landscapes, and the role is going to increase due to current situation in the world. We have also the topic of register of processing activities, as it's a very GDPR related provision, but there are some specifics in regarding the ROPA, and there are also certain rules that should not be compared with any other regulations. For instance, this annual assessment that is conducted by the DPO, how it should be done and what it should include. It's also should be a subject of different webinar or the course. And if you are interested in learning those aspects in detail and in comparison with the GDPR, because many of you are probably aware of the GDPR provisions, then please keep in touch with us. We would probably spread information about our new course that is being developed right now. And this course is focused on the UAE regulation and data protection. It could be a very helpful tool for you to become a DPO in either Abu Dhabi, Dubai, or UAE, and also would allow you to map new knowledge on an existing map of European data protection. Maybe we could sum up, make certain conclusions that we came to while preparing for this webinar. I will probably start with GDPR related, the relations, close relations between UAE legislation and GDPR. It seems to be encouraged. It seems to develop certain provisions that were introduced by the GDPR. And three legal regimes that are present, actually like two data protection regimes on the level of the federation and on the level of free zones. And unfortunately for us, for those people who work with data protection, they have different provisions. So it's very important not to mix them up. It's very important to distinguish them and know how they interplay between each other. And Denis, would you like to proceed about the differences?
We have some differences when we compare different legal approaches to the data protection. Usually we first of all pay our attention to the similarities, and differences and distinguishes usually become in the shade. But from my point of view, we should first of all pay attention to differences. And in this case, in this particular case, in the case of United Arab Emirates, we have some key differences between GDPR and between the approaches which were adopted in the United Arab Emirates. And I would like to point out that the role of the United Kingdom approach was important, especially it's the case of Abu Dhabi. And we have direct influence of ICO approach, of ICO guidelines. And also we know currently that according to the project of British government of the project of data protection reforms, Dubai International Financial Center in the list of the top priorities to be recognized as a regime which provides adequate protection of the rights of data subjects. And also we have similar legal institutions and similar legal approaches, but despite the fact that we have just textual identical legal provisions, they work in practice differently, and we should bear this in mind.
I think that's it. Thank you everyone for visiting this webinar, for asking questions. Maybe you'll have certain questions after our webinar ended, so don't hesitate to ask them through email. We'll be glad to help you. We, Siarhei, Varankevich and Denis Sadovnikov, were here to explain the basics and of the UAE regulation of personal data with a focus on material and territorial scope and data protection. Thank you everyone, and see you at the next webinars or at our training.